The second item on the order paper is a debate on an urgent matter of national importance in terms of Rule 130. In the name of Mr. B.N. Herron, on failure of government to extradite persons implicated in corruption, as demonstrated by the recent case in the United Arab Emirates and the consequences thereof. I now recognize the Honorable Herron.
Thank you, House Chair. House Chair Leonardo da Vinci famously said, "I've been impressed with the urgency of doing. Knowing is not enough, we must apply. Being willing is not enough, we must do." 4 days after we were told in April that South Africa's application for the extradition from the United Arab Emirates of the Gupta brothers had failed, I submitted a request to the Speaker in terms of Rule 130 for a debate on an urgent matter of public importance. 2 months later, here we are finally to discuss the urgent matter. While we waited, the subject was sliced, diced, chopped, analyzed, spun by just about everyone with an opinion besides us. We who were elected to hold government to account have twiddled our thumbs long enough to give government time to ponder its losses and announce a new strategy. Leonardo would have been impressed at the urgency of the Speaker's response to my request for this debate. But what's the point in declaring an urgent matter without treating it as urgent? Urgency is about determination to get something done. It's about something requiring immediate attention, speedy action, and acting with insistent necessity. Urgency is also about a state of mind that enables us to identify our priorities and ensure that we address them meticulously and effectively. I couldn't find a single word with the opposite meaning to urgency. The thesaurus suggested languid, lazy, sluggish, amongst other possibilities. Lack of urgency arguably describes the state's overall legal response to the entire Gupta brothers saga. On the UAE's version of events, our extradition application lacked the determination to get something done. It lacked the meticulous attention to detail that acting with insistent necessity demanded. It lacked urgency. The application lacked the necessary urgency to succeed, just as Parliament lacked the urgency to schedule this urgent debate urgently. Lack of urgency has regrettably become a defining characteristic of government. We know that extradition applications are fraught with difficulties. Applicant countries must often go to extraordinary lengths to convince the holding country to extradite citizens or residents to face trial. It's a high-stakes endeavor that demanded the very best from our prosecuting authority and members of the executive. The minister's remark that the extradition was denied on a technicality seems to confirm the UAE's version that South Africa did not meet the legal requirements of the extradition agreement between the two countries. We did not submit a live warrant of arrest in support of our application. The application was considered with a cancelled warrant of arrest, and this is why the extradition application was apparently denied. A failure of meticulousness betraying a deeper lack of urgency. It could be regarded as a technicality. Alternatively, an unnecessary and careless error, the types of error that should be inconceivable in such high-stake cases. Chief Justice Raymond Zondo handed the last parts of his state capture report to the President a year ago. The report unraveled a web of questionable companies and individuals in the state and outside, including members of the executive and a former state president, who allegedly colluded in the theft of billions of rand of taxpayers' money. The Gupta brothers, rightly or wrongly, became the poster boys of alleged state capture. For South Africans to believe in the integrity of the billion-rand investment in the Zondo Commission is inextricably linked to their prosecutions. So there was a lot riding on the matter, the billions of rand and the nation's belief in self-esteem. That's why we asked for this urgent debate on a matter of national public importance. We've listened to thousands of words from the minister and his department, seeking to assure South Africa that they did their best and seeking to diplomatically place the blame for the failure of the extradition application on the UAE. Besides details of the state-to-state engagement or non-engagement behind the scenes, we know very little. Given the failure in which South Africa was an applicant in a UAE court, we have questions about whether we consulted the right people in the UAE with the necessary expertise and knowledge of the UAE system of justice. If ours was a purely technical mistake, surely this would have been picked up and addressed had we been taking advice from people of high competence. Nor can we avoid questions relating to our own competence. For the past 5 years, we've been regularly assured that the criminal justice system, especially the National Prosecuting Authority, was being increasingly resourced so that it could prosecute those who have stolen from us. The arrest of the Gupta brothers on the back of an Interpol red notice was a very significant step to demonstrating this growth. It reflected a National Prosecuting Authority that no longer followed the instructions of political masters like sheep. But looks can be deceptive. The failure to extradite the Guptas was a devastating blow to all patriotic and law-abiding South Africans. The fact that they slipped through the NPA's fingers, free as birds to holiday in Switzerland and take up citizenship of Vanuatu, rubs salt in the wound. If this is a result of sloppy legal work, then heads should roll. We know that the minister met his UAE counterpart last week, and they established a joint task team which will commence work next week on a fresh extradition process. Make no mistake, the Guptas will take the best legal advice, and if they advise that the new agreement is threatening, they'll already be taking steps to reduce their exposure in the UAE. South Africa is buckling under multiple disorders, from the rising cost of living to poverty and food insecurity, and from broken electricity supply to failing passenger and freight rail transport. We need to hear from the minister how those who created this undeserved suffering for their own personal greed will be held accountable. This debate was proposed on the back of the failed extradition application of the Gupta brothers, but its national importance is about much more than this particular extradition and prosecution. It's more about the correction and stabilization of our country's critical institutions, about taking back our democratic and constitutional order from the hijackers. The response I would like to hear from the minister goes beyond calm reassurances to about actual progress. It's bigger than the Guptas. We can't foresee whether they'll ever face prosecution here, but there are many prosecutions we should see that do not require extradition and which would begin to satisfy our need to see some consequences for looting and derailment of our developmental state. With respect to extraditions, we know the status of the Guptas and the curious matter of the Bestas, but there's another decision relating to the extradition of a corruption fugitive, Michael Lomas, that could open a whole new can of worms. Lomas is implicated in a 745 million rand fraud and corruption case at the heart of the Kusile power station failures and the destruction of Eskom's planned power supply. Will we get him extradited to come back and stand trial, or will we be denied this because our prisons are regarded as too dangerous or unfit by the UK Home Secretary? Will that be our next technical setback? Thank you, House Chair.
Thank you, Honourable Member. The next speaker is the Honourable Ramolobeng.
Thank you, House Chair, Deputy President of the country, Minister of Justice and Correctional Services, honorable members. The traditional international law requirements of independent statehood are barely open to question. The entity involved must have territory, a population, and a stable and independent government to which the bulk of the population renders habitual obedience. A fourth requirement is sometimes postulated that the state must have the capacity to partake in international intercourse. The implication of a sovereign state is that it has control over its own territory. It also implies that states should not interfere with each other's domestic affairs. The international community derives substantial benefit from a borderless global world, but as a result, it also has to deal with the negative impact of globalization on international crime. Internationally, the following crimes or conduct pose a particular challenge: physical crimes committed across borders, such as drug trafficking, human trafficking, money laundering, environmental crime, and terrorism. Cyber crimes committed within one state, but the effect of which is felt in the territory of another state or in multiple states, such as the release of malware and the flight of a person accused of a sentence for a physical or electronic crime from the state in which this took place to another state. House Chair, in criminal matters involving persons or in two different states, the correct and acceptable procedure would be for a requesting state to apply to another state and the requested state for cooperation in the form of mutual legal assistance regarding the gathering of evidence or extradition of the perpetrator. Cooperation between states is governed by public international law between the requesting and requested state and the domestic law of the requested state. Chair, it is generally accepted that once a crime has been committed, it should be investigated. The perpetrator should stand trial and on conviction be punished for his unlawful conduct. The challenge that arises is how this could be ensured where the perpetrator is outside the borders of the state in which the crime was committed or where the effect of the crime was felt. The need for effective international and transnational criminal justice has to be balanced with respect for state sovereignty and territorial integrity. It must be noted that the law enforcement agencies of one state cannot just enter a territory of another state and capture the perpetrator, nor can they enter its territorial space and collect evidence of the crime, as this would in itself be a violation of the international law. Such conduct will not only infringe the sovereignty of a state, but also violate the principle of non-interference in the domestic affairs of another state. Chair, there is consensus in international law.
So that's alone.
Order, honorable member. May I request the table staff, ICT, just to switch off those microphones because they are not recognized. Let's not allow it to interfere in the debate. Please continue, honorable member.
Thanks, House Chair. There is a consensus in international law that a state does not have an obligation to surrender an alleged criminal to a foreign state, because one principle of sovereignty in that is that every state has legal authority over the people within its borders. The requested state may surrender the requested individual only after there has been compliance with an extradition agreement between the requesting and the requested state and the domestic laws of the requested state. In President of the Republic of South Africa versus Kwaglin, the Constitutional Court pronounced on the nature of extradition, recognizing that it involved more than international relations or reciprocity and indicated that involves three elements: acts of sovereignty of the part of the two states, a request by one state to another state for the delivery of an alleged criminal, and the delivery of a person requested for the purpose of trial and sentences in the territory of the requesting state. House Chair, the extradition law thus straddles the divide between the state sovereignty and comity between states and functions at the intersection of domestic law and international law. It must be noted that extradition is not an easy process. It is a legal and technical one. With regards to the Guptas, it must be noted that government has not simply folded its arms. From February 2022, when the Interpol confirmed that red notices had been issued for the Gupta fugitives, much has taken place. In June 2022, the UAE informed South Africa and Interpol that Mrs. Atul and Rajesh Gupta have been arrested by the police in Dubai. And House Chair, in July 2022, South Africa delivered the formal extradition request to the authorities in the United Arab Emirates. From September 2022, the department has consistently made communication with the authorities of the United Arab Emirates and our embassies, requesting regular updates on the matter. On the 6th of April 2023, the department was provided with a note verbally from UAE and learned therein that the extradition hearing had been concluded in Dubai court on the 13th February 2023, and our extradition request was unsuccessful. House Chair, on the 5th of June 2023, the Minister of Justice and Correctional Services met with his counterpart in the United Arab Emirates with objective of enhancing the partnership and in mutual legal assistance and extradition matters between the two countries for the mutual benefit of both nations, as well as the Gupta extradition processes. It has also been reported that a technical joint tax team will meet to go through the extradition request and the additional mutual legal assistance that South Africa should provide. We must appreciate that different states employ different legal systems, and that for successful extradition, there needs to be cooperation among states, as it is not an easy process. A requesting state relies on the prosecuting authority of the requested state. Chair, we are hopeful that this case and that of the case in Malawi of the Bushiris will yield positive results and justice will be served. I thank you.
Thank you, Honourable Member. The next speaker is the Honourable Breitenbach.
Thank you, Honourable House Chair, Honourable Members. We are here to debate the failed extradition of the Gupta brothers from the United Arab Emirates to South Africa. This case has captured the attention of the nation and has raised significant questions about international cooperation, rule of law, and the fight against corruption. First and foremost, we need to understand the context. The Gupta brothers have been at the center of corruption allegations and investigations in South Africa for several years. Accused of exerting undue influence over key government decisions, the Gupta family's alleged involvement in state capture has had severe repercussions on the country's institutions, economy, and public trust. Their extradition has been sought to hold them accountable for their alleged crimes and to restore faith in the rule of law. South African citizens expect them to be held accountable and to return the vast sums of money stolen. One wonders why they were permitted to leave in the first place. However, despite South Africa's extradition request and the extensive evidence presented, the UAE's decision not to extradite the Gupta brothers has left many baffled and disappointed. This turn of events raises concerns about the effectiveness of international cooperation in combating transnational corruption and ensuring that justice is served. One key issue that emerges from this case is the importance of a robust legal framework for extradition. Extradition treaties and agreements play a crucial role in facilitating the surrender of individuals accused of crimes across international borders. They establish the legal basis for extradition requests and outline the conditions under which extradition can be granted. The failure to secure the extradition of the Gupta brothers highlights the need for stronger extradition mechanisms and closer cooperation between countries to prevent potential loopholes and ensure that justice is not compromised. Moreover, the case underscores the significance of international political will and diplomatic efforts in extradition matters. Extradition processes can be complex, involving not only legal considerations, but also political and diplomatic dimensions. It requires close cooperation and coordination between the requesting and requested countries. The inability to secure the extradition of the Gupta brothers raises questions about the effectiveness of diplomatic engagement and the extent to which political factors influence the outcome of the case. Another critical aspect that emerges from this failed extradition is the need for international cooperation in combating corruption. Corruption is a global issue that transcends national boundaries and it demands collective action to address it effectively. The Gupta case highlights the importance of collaboration between countries to track illicit financial flows, share intelligence, and ensure that those accused of corruption face justice, regardless of their geographic location. The failure to extradite the Gupta brothers not only undermines South Africa's efforts to combat corruption, but also sends a discouraging message to the international community regarding the fight against this pervasive problem. Furthermore, the failed extradition of the Gupta brothers raises concerns about the integrity of global financial systems and the need for enhanced measures to prevent money laundering and illicit financial activities. The Gupta family's alleged involvement in corruption and state capture has been closely linked to illicit financial flows. This case emphasizes the importance of strengthening international financial regulations, promoting transparency, and cooperating to combat money laundering and financial crimes. By doing so, we can prevent individuals from exploiting loopholes and evading justice by seeking refuge in other jurisdictions. This must start by finding out where the Guptas actually are, and it's no good, Mr. Minister, gallivanting in Abu Dhabi unless we actually know that they're there. In conclusion, the failed extradition of Gupta brothers, semantics. In conclusion, the failed extradition of the Gupta brothers from the United Arab Emirates to South Africa has been a setback in the country's fight against corruption and the pursuit of justice. It raises concerns about international cooperation, the robustness of legal frameworks, and the need for collective action in combating corruption. As an aside, Mr. Minister, I asked 4 weeks ago for a copy of the extradition documents. I still have not received the courtesy of reply. What seems to be the problem? Thank you.
The next speaker is the Honorable Tembe Kwayo.
Thank you, Chairperson. The most dangerous criminals in the world today are those who are able to commit crimes in multiple jurisdictions. They are dangerous because they are able to move assets across countries and they are able to escape from one jurisdiction to another. It was for this reason that International Cooperation in Criminal Matters Act and the Extradition Act were enacted in order to facilitate the prosecution of criminal offenders and enable their extradition from wherever they may be in the world. But as a lawyer himself, the Minister of Justice knows that the substantive element of a crime are as important as the procedural requirements for prosecuting crimes. As we cannot simply extradite a person without following our due processes, other countries too have their own procedures before extraditing persons of interest to us. What we know for a fact in as far as his request for the extradition of the Guptas to account for their crimes in South Africa is that the UAE refused our request because of a number of foolish administrative and legal mistakes from our side. This was a ruling made by a court in that country after finding that there were material defects with the papers submitted by South Africa in their request for the Gupta family members to be brought to this country to account for their crimes. Interestingly, the UAE made the decision in February this year and claimed that they had been communicating with their counterparts in this country at every possible step. It was shocking, therefore, that the Minister of Justice claimed ignorance and shock when South Africa finally communicated this in April. This raises a number of questions. The first one is whether or not the extradition request was deliberately bungled by Mr. Lamula and his department in order to shield the Guptas from ever accounting for their crimes. This is possible. The Gupta legacy benefited far more than the former president and those close to him. Past and present leaders of ANC simply found an easy scapegoat in former President Zuma. They themselves were used and are still used by big business to hollow out the state in return for crumbs. They are all complicit in the commission of these crimes and will do all in their power to prevent those with international footprint from ever accounting for their crimes, because if they do so, the leeches in the ruling party will also be exposed. The second question relates to the competency of those who made requests for the extradition of the Guptas specifically, and the capacity of the NPA under Batohi to procedure any of the so-called state capture crimes more generally. How is it possible for a country awash with a number of legally astute people to miss basic requirements needed to assure the UAE government that their concerns are taken care of? We know for a fact that we cannot extradite a person to a jurisdiction to which they face a death sentence, for example. We would want to ensure that there are these guarantees before we extradite. So why do we fail this basic test to satisfy the legal requirements of the UAE? It might be sheer incompetence, which works quite well for the corrupt leeches leading our government. The NPA itself is utterly incompetent and are led by a very incompetent person in the form of Shamila Batohi. They have not prosecuted a single person out of the so-called state capture circus run by Raymond Zondo. They failed to prosecute our current president despite there being prima facie case of corruption relating to his Phala money laundering scheme. They failed to prosecute Mr. Godongwana, where there was evidence that he sexually assaulted a female worker at a massage parlor. There is no way that they would ever be able to lead a successful prosecution of the Gupta family. All this is deliberate. The capacity of the state is weakened so that those using the state for their personal bank continue doing so without even fearing the risk of arrest and successful prosecution. I thank you, Chair.
Thank you. The next speaker is the Honorable Hlengwa.
Thank you, House Chairperson. Technical mistakes in the bungling of this extradition is a clear indication that government is sleeping at the wheel and tripping from one failure to another. The founding provisions of our country's constitution state we have a multi-party system of democratic government to ensure accountability, responsiveness, and openness. However, under the current government, the value of accountability has been reduced to a phrase only used when doing damage control. For a brief moment, the so-called New Dawn, it seemed that South Africa was making progress towards tangible accountability through the Commission of Inquiry into State Capture. However, the government's failure to extradite persons implicated in the Zondo Commission report has left us right back where we started before the commission. Rightly, this has been confirmed by the Transparency International's 2022 Corruption Perception Index, as it indicated that South Africa is now ranked 72nd out of 180 countries, which is a score of 43, the same as it was 11 years ago. The Commission of Inquiry into State Capture has cost South Africa almost 1 billion rand in the hopes of saving the country from further looting by corrupt government officials. However, this is merely a surface value figure. State capture in South Africa has left SOEs such as PRASA, SAA, and ESCOM accumulating a total of 331 billion rand in bailouts since 2013-14, with ESCOM accounting for 55%. These entities have failed due to persistent looting that has been enabled by the government. Instead of bringing economic development, employment opportunities, and contributing to South Africa's GDP, we are stuck with an inept department. This is the real cost of corruption. This is why we needed to extradite and bring the Guptas back to justice. The work of the Zondo Commission is invaluable and important, and therefore the South African government needed to show a stand of ethical commitment to all its citizens in bringing those implicated in the state capture to justice. The denial of extradition is a travesty of justice, as this has essentially rendered the work of the Zondo Commission as nothing more than wasteful expenditure. In the bilateral meeting between the Minister of Justice and Correctional Services and the Minister of Justice of the UAE, an agreement was seemingly reached to quickly address the issues by setting up a joint task team of prosecutors from both countries. It is believed that the establishment of this task team will allow both countries to collaborate closely to ensure the fair administration of justice. However, one sincerely hopes that this is not just government's kick-for-touch tactics, as we have become accustomed to in the ongoing Section 194 inquiry into the public protector. The fact that government is only now starting this process, and probably more properly this time, we hope, is in itself unacceptable, because it begs the question, why has it taken so long? This is not only an embarrassment to our country, but it is also dangerous, as it indicates that we do not have the adequate procedures, knowledge, skills, and expertise in place to deal with extradition matters. Today, we are discussing corruption, theft, fraud, and looting. But what happens when tomorrow it is a murder? It goes back to the ineptitude we have seen. Why have we allowed those implicated in matters that affect our entire nation to escape and hide in another country? We believe that South Africa can ill afford any more time and money wasting into these matters. It is actions that speak louder than words, and the nonchalant approach to these convictions by the government has created the very real perception that South Africa itself is not committed to eradicating corruption by others. I thank you.
The next speaker is the Honorable Wessels.
Honourable House Chairperson, on the 7th of April 2023, many ANC members were very relieved at the outcome of the failed extradition of the Guptas. Because, House Chairperson, it's not so much about the protection of the Guptas as it is about a lot of cadres that will be implicated in state capture when such court cases will take place in South Africa. It's not necessarily incompetence, although we know that most departments and most government officials are incompetent under the ANC government. This is less about incompetence and more deliberate incompetence to protect cadres within the ANC. Because, Chairperson, we also have to remember that state capture and what was done in this so-called 9 years were not done by the former President Zuma alone. It was done under the watch of a cabinet which a lot of members in this House were part of. The Deputy President at that stage is the current President of South Africa. So it's not 9 lost years that this ANC caucus and this ANC cabinet can just say they had nothing to do with. They had everything to do with it because they allowed it, but they are still allowing it now because, Chairperson, there's no consequences. And that is a golden thread within all the problems in South Africa. No consequence management. From local level to provincial level, to national level. And then this caucus and members of this caucus of the ANC in each debate says that they are eradicating corruption, that it's a new dawn, that they are doing everything in their power to bring about change and that there's no corruption anymore. But then corruption takes place daily and there's no consequences. And this failed extradition of the Gupta brothers is once again a sign of the incompetence, but also the lack of consequences for those who transgress. The fact that we have commissions of inquiry and commissions of inquiry, but then nothing happens. And that go back since 1994, where that happened. From the arms deal up until state capture. There is a tradition and a culture of no consequences. And corruption, Chairperson, is stealing away the potential of South Africa. People are suffering. People are hungry because of corruption. Because there where a road needs to be built to bring about economic growth, there the money to build that road is stolen by ANC cadres, and nothing is done. There in a municipality like Kopanong in the Free State, where there's no water currently, the mayor can drive a 2 million rand vehicle, and the ANC does nothing about that, but the people are suffering. State capture is a symptom of this government that does not care about the people out there. You do not care about the livelihoods of South Africans. You actually only care about yourself, your own power, and you do not care to promote a new South Africa where there is no corruption. And this
Honourable
failure
Member, your
by
time has expired.
the Minister's Department is a sign thereof, I think.